Does a prosecutor have to allow a blind plea? I'm Tulsa Attorney James Wood, and that's the question that we have. So we're talking about a criminal case in the state of Oklahoma. Normally, you get the formal charges, you get the discovery, you do the legal research, you negotiate with the prosecutor, see if a reasonable plea deal can be worked out or an agreement to dismiss the case, whatever the case is, and you don't get a reasonable plea deal worked out. So you've got the opportunity of taking whatever deal's on the table or going to trial, or you have that other option, a blind plea. So when it's a blind plea, that means that you are pleading guilty or no contest or making an altered plea. In any case, allowing yourself to be found guilty without the benefit of a plea agreement in place. Then it goes to the judge. The judge can sentence you anywhere within the range of punishment for that crime. And the question that we have is, if you're looking to do a blind plea, does the state, the prosecutor, have to agree to it? The answer is no. They would have to agree if it's a plea deal. If it's not a plea deal, you're cutting them out completely, going straight to the judge, entering a plea of guilty, requesting that the judge sentence you. Now, the prosecutor is going to be able to argue sentencing, just like the defense is going to be arguing sentences, but ultimately the state cannot prevent you from entering a guilty plea and doing a blind plea, and it is ultimately up to the judge to make the determination of what the sentence is going to be at that point. If you're dealing with that circumstance, though, there's usually a lot of things you want to look into before you try to do the risky move of a blind plea. You're going to want to talk to an attorney about that privately and confidentially. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.